Dear students, today we are going to discuss about the two intellectual property rights. One is geographical indications and another one is trade secret. So, what is a geographical indication? And geographical indication is the one community right, which is known as a community right, not owned by an individual. The entire intellectual property rights talks about private rights, and this is the one intellectual property category intellectual property which talks about community rights, which cannot be owned by an individual. So, its roots from Paris Convention, and then J protection is in through various jurisdictions or different names, and ultimately it comes to the TRIPS agreement. The common name which is put is geographical indications protection. India also passed a law in accordance with the TRIPS obligations, and then next we will see the trade secrets, undisclosed information, and there is, even though there is no law in India, and we will see the Indian scenario in this particular class. So, I was asking what is a geographical indication, and this picture shows the first geographical indication of India, that is the Darjeeling tea. So, there are two terminologies, one is Darjeeling and another one is tea. So, what is intellectual property in it? So, if a particular product have a reputation, a uniqueness because of a region or a particular place, then it is considered as a community intellectual property law. That is the geographical indication. An indication, a goods which are directly related to, not services, a goods related to a particular region or a place or a country, then it is known as geographical indication. A geographical, it originates from a particular geographical area which have a special reputation, then it can be considered as a geographical indication. And Darjeeling tea is the first geographic indication and very world famous as well. So, the name or the indication must be associated with a particular place to identify that product, and India presently have more than 450 geographical indications registered from different parts of India, and these particular products are associated with a particular geographical area of India, and also this particular product identified in the name of that particular place with a special characteristic and with a special reputation, then only it can be considered as a geographical indication. So, here it very clearly says, the section 3 of the GI Indian Act as well as article 22 of the TRIPS agreement. Here it says that indication which identify a good as originating in the territory of a member or region or a particular locality in that territory with a given quality or reputation or other characteristic of a good is essentially attributable to its geographical origin. It may be skill of the people, it may be a special characteristics of the raw materials which are used from a particular region, it may be even climatic conditions which made that product very special. So, it can be aroma, it can be the qualities, it can be the chemical composition, it can be the skill of the people, those who are making that particular product from that particular area. And India, geographical indication is protected for 10 years, which is provided. And a special protection is given, so contained under article 24. And also you can see that for a special protection with regard to wines and spirits. So, the special protection is included in the TRIPS agreement. In the TRIPS agreement is mainly because of the pressure from the European countries, those who produce a lot of wines and spirits. So, it means that every member country has to provide special protection to wines and spirits as well in their territories. And we have registered around number of products, around 7 geographical indications from the state of Odisha. So, I have registered, which includes the famous Sambalpuri Bandha sari and fabrics, and others is Dalapatar Parda and fabrics, Bomkai sari and fabrics, Habaspuri sari and fabrics, and Berhambur Patta, Fodakumba sari and Joda, Ganjam Kevda root and Ganjam Kevda flower, that also, and Part B registrations are also done for the Sambalpuri Bandha sari and Bomkai sari. So, this is our experience with registering geographic indications. And in 2022, I have published this book, a handbook on geographical indications in India. So, the students can refer to this book for this particular module for knowing more about the geographical indications from India. So, why you should protect? Why you should protect geographical indications? And you saw the 2 logos. The first logo is Darjeeling logo, which is again a registered registered geographic indications from India. And around 10 tons of tea is produced only from the Darjeeling area, and this 10 tons of tea is completely managed by the Tea Board of India. And Tea Board is the registered proprietor of Darjeeling tea, and they produces only 10 tons, but all over the world around 16 tons. This is the some of the studies revealed 16 tons of tea are distributed all over the world as Darjeeling tea. So, where the another 6 tons coming from? It comes from various part of the world, and they tame it, label it as Darjeeling tea, or it's deceptively selling it as Darjeeling tea. So, this picture you can see that and the Tea Board has fought a case in Paris in France against a certification mark which is known as Mongoji device mark. You see the difference? The only difference is the lady become a Chinese lady and the tea tig become a flower, and the shape of the lady and the attire of the lady has changed, that is all. But otherwise it is a clear deceptive mark, and the Tea Board fought this particular case and they won the case. So, it is very simple. If you do not protect your intellectual property and somebody will take away your intellectual property and they will protect and as an intellectual property, and they will file a case against you for violation of their intellectual property if you market. So, this case was successfully defended by the Tea Board in the Court of Appeal of Paris, and we have successful the cases of geographical indications. Araku coffee. Araku coffee is this particular area is in border between Odisha and Andhra Pradesh. So, this particular area is completely the very poor farmers, especially belongs to the tribal families. They cultivate this particular coffee, and this coffee have a very successful story as a geographical indication, and before it was registered as a geographical indication, and the farms, this coffee, you can see the red coffee beans is completely scattered, and the agricultural the inputs, there is no coordination, and there is no farm practices, uniform farm practices. So, everybody was adopted different practices, and the farm product quality is not uniform. So, in that particular time, there is a private organization is in Mumbai, Nandi Foundation, and with the help of experts, foreign experts even, they took over this particular the case, and they registered the Araku coffee as a geographic indication, and all the farmers were trained, and they form a cooperative to process the entire Araku coffee in a single unit, and all the tribal farmers were trained on farm practices. So, without fertilizers and without pesticides. So, it become the story, the success of the story is that it become a number one coffee in the world, and now it is it is exporting to other parts of the world, and the farmers are getting benefit out of it. And we can see what is exactly a GI. The Indian the GI Act, which defines geographical indications in relation to goods, means an indication which identifies such goods as agricultural goods, natural goods, manufactured goods as originating or manufactured in the territory of the country. So, it talks about three categories. One is agricultural goods, second is natural goods, and third is manufactured goods. So, which originating in a particular territory or a region or locality in that territory, and most importantly the prerequisites with a given quality, reputation, characteristics, and essentially this is attributable, this reputation and quality attributable to that geographical origin. So, then only it can be considered as a geographical indication. It must be related to or connected with that geographical origin. So, in some countries like Europe, it is known as appellation of origin, and it is again you can see the name is different, but it is ultimately now the TRIPS agreement, which clearly says its geographical indications, identified territory, special quality, characteristics, uniqueness. It may be due to the climatic conditions or the production process, unique production and process characteristics, which should be taken into consideration for the GI registration. And the most importantly, as I said, that the geographical indication is considered to be a community right. Even though it is all intellectual property law, so all intellectual properties are private rights, here it is a community right. The reason is no individual can apply for a geographical indication registration, only a community of people, association of people, association of producers, other organizations, and even governmental authority can only apply for registration. So, the only condition prescribed are they represent the interest of the producers. So, there is a prescribed application form, and the Indian registry is in Chennai, and you can apply now online as well and paying prescribed fee, and after examination and other things, and they issue the registration certificate. So, who is the producer? So, there are three categories of goods, which we already said, that agriculture goods and natural goods, and also the industrial goods. So, any person dealing with these goods, any person dealing with these handicrafts, any person dealing with industrial goods, any person dealing or trading with the particular product, they also can be a producer. So, trader is also can be considered as a producer. So, as I told you, here you can see it clearly says the protection to 5 sectors in the Indian Act: agricultural goods, natural goods, manufactured goods, handicrafts, foodstuffs. So, Indian law talk about 5 categories. TRIPS agreement talks about 3 categories, that is the first 3: agriculture, natural and manufactured goods. And most importantly, India, the largest number of registrations are on handicraft, and then comes the agriculture goods. So, natural goods and manufactured goods are very less. And if you look into the registrations, we can see huge registrations, huge number of registrations, around maybe 60,000 to 1 lakh registrations all over the world, worldwide. And OECD is the largest contributor with 10,000 registrations. China is reaching to the registered, total registered trademarks to 10,000. And India, I would say that one of the largest country with the largest resources, hardly registered it is going to be 500, hardly going to be 500. So, there was a very recent discussion in the GI registry to increase this number to the maximum like other countries. So, even though we are in 25th or 27th years since the establishment of the WTO, we are able to register only for 50 or 500, maximum to the tune of 500 applications, processing of 500 registrations, with the largest country with the largest resources and n number of geographical indications. So, if you want to cash it out, the economic benefit, then definitely you have to register these particular products. So, the Indian Act even defines what are the goods which includes, and comes why the GI need protection, why you should protect. It is very simple. We saw the Mongoji and the Darjeeling tea case. It is from the consumer point of view. The consumer must get the quality product, originally belongs to that particular region. Otherwise, the Darjeeling tea will be made, can be made in Kolkata or in Nilgiris or in other parts of hilly areas of India, and it can be sold as Darjeeling tea. But the GI Act prohibits that. So, there can be, mainly the consumer should be protected from misrepresentation and commercial exploitation. Commercial exploitation is prohibited. That means you cannot duplicate the products. So, here we can see another example. So, I got these 2 sarees from the Odisha, and one is handloom and other one is made up of powerloom. And as a ordinary uneducated, even educated people cannot identify which one is handloom and which one is powerloom. So, the powerlooms duplicates and sell it as Sambalpuri sari, one of the varieties of Sambalpuri sari or Habaspuri sari specifically. So, as an ordinary consumer, you cannot distinguish, and you can see what is the original one and what is the the duplicate one, these 2 sarees, and we find it from the market. So, in order to stop, in order to prohibit this kind of duplications or exploitations, infringements by the commercial exploiters, you require geographical indication registration. So, now the Sambalpuri sari is registered as a geographical indication, and the registration is, the proprietor is the department of the handloom, which they can take action against the people, those who duplicate commercially using power looms. When they duplicate, they can take action, they can take civil action as well as criminal action under the geographic indications. So, the benefit is ultimately go to the producers, benefit basically go to the customers, the users, and benefit of registration. And there are Part A registration and Part B registration to GI. And Part B registration, Part A registration is the proprietor who is the owner, and Part B, all the users, all the traders can be registered under the authorized user. Only the authorized users have the right to deal with this particular product. Otherwise, it is going to be an infringement. So, Part A and Part B registrations in India, one of the lowest registrations of Part B are in India. So, the beneficiaries are not registered. So, and the basic benefit of geographic indication registration is, first of all, it confers a legal right on the community which is registering, the association which are registering. 2, it prevents unauthorized use of the registered geographic indications by others. Only the beneficiaries and the proprietor can use this particular product, deal with these products. And also legal protection to Indian exports. And also the price premiums, it promotes economic prosperity, especially the rural people, because most of the geographic indications are from rural areas in India. And it gives protection in other jurisdictions of WTO member countries. So, some very few of them, so I will show some of them to understand what is this geographic indication. This is the Machilipatnam Kalamkari. It's a very beautiful one hand export market. Then bell and brass craft. So, Buddhidip bell and brass craft, which is world famous again from time immemorial period, and leather puppetry, one of the oldest arts, the leather puppetry, and then the famous Tirupati Laddu, again it is very controversial, and many litigations are under the Tirupati Laddu. Then Bobli Veena, the equipment, the music equipment, and then mangoes, agriculture product, and again some of the toys, so which belongs to this Etikopka. And then you can see the stone carvings, the natural products, the famous stone carvings. I have shown you only very few the geographic indications which is available in India. So, every one art form or the product belongs to a particular geographical region. And we talked about authorized users, and authorized users, all the people, those who uses or the beneficiaries can be registered under the Part B registration as an authorized user. So, now they made it the very simple, the process to very simple, and an application, a half page application with a 10 rupees fees can register the geographical as an authorized user in India. So, this is to encourage, this amendment is made very recently to encourage more and more people register as a beneficiary under the geographical indications. And also you can see this is a very simple application for Part B registrations, and the government has done it with the objective of increasing the number of the registered beneficiaries in India, so that more and more people will be getting benefits, economic benefits. And also as I already said that there are civil remedies as well as the criminal remedies. So, civil remedies includes like any other intellectual property law, imposition of fines, then forfeiture of goods, confiscation of goods, then account of profit, and then the infringing labels. So, the taking into custody of infringing labels, indications, destruction or erase. And criminal remedies include imposition of fine or imprisonment or both. So, like Copyright Act, GI Act is another act with imprisonment or criminal remedies, but in India hardly this particular provision is used against the exploiters or infringers. So, and also you can see that the wide powers are given to the trademark registry as well as the proprietor, but so far there is no much cases in India. No much cases on in India on these against infringers or geographical indications. And again comes the economic benefits. So, Pashmina, Kulu Pashmina is a registered geographical indication, but I have taken these pictures from a e-commerce website. You can see the prices 6,658, very highly priced, a price premium. But the question is, these e-platforms are making lot of money, lot of price premiums which they are making. The most important question is whether these price premiums are going to the manufacturers, the users or the beneficiaries. So, in India there is no provision for benefit sharing in geographical indications. So, it is very important this price premium. So, it is 6,000 rupees. I do not have any idea that what is exactly the price which is going to the the producer of these Pashmina stalls. So, it is a very beautiful stalls. Pashmina stalls are is famous worldwide. We export it and on a very high price, but actually whether these price premiums are going to the people or not, that is very important. So, the economics of geographic indications is very important. Yes, everybody knows that these are highly quality products and there is a lot of potential in the international markets, and it gives consumer identity and quality control, and presently the quality control of all geographic indications are very weak. Labeling and quality control is one concern, and if it is marketed properly, the lot of farmers, lot of producers in remote regions, artisans of India, they will be benefited, and also the government can make collective brands. That is also because if you make whatever it is, if there is no economic benefit, then and there is no significance for protection of that intellectual property. And as I told you that the prices, the price premium should reach to the lowest level of producers, and there must be a benefit sharing mechanism to be to the poor people. Then also it can be there are a lot of suggestions with regard to the geographical indications, and there must be consumer benefits, lot of consumer benefits which can be. Now, the government of India come out with a common logo for Indian geographical indications, but nobody uses it because there is no provision for mandatory use of this particular logo other than the individual logo. So, this should be made mandatory, so that everybody will use, every product they will use this, so that the people also can slowly identify that yes, this is the Indian geographical indication. So, the government to make mandatory for this to use this particular logo. And you can see we have registered the Sambalpuri sari from Orissa, the famous Sambalpuri sari, and this kind of famous celebrities give a price premium to the products. So, the marketing strategies, appropriate marketing strategies to be adopted, and one of the very successful product from Odisha is Sambalpuri sari, which is exporting, very huge export market with a price premium. So, this can happen only when it is properly marketed with the help of different people. So, we have registrations are done, and the certificate is given. So, you can see the logo. So, we have not only registered this textile product, but also under class 24, and the logo is also registered, Sambalpuri sari and fabrics. So, this kind of registrations will empower the people those who are producing this with a price premium, with an economic benefit. So, if that economic benefit is not really going to the people, then there is no need of protecting this as intellectual property as a community right. So, I already said that the story of Araku coffee, the Araku Valley Arabica coffee. Now, you can see the shops in the streets of Germany. The shop is not in India. So, you can see that how a good branded product, GI product can be exported and you can leverage price premium. This Arabica coffee shop is in Germany. So, it is branded and marketed in beautiful packaging systems. So, you market it, success story. So, there are so many success stories in India, and this should be spread to each and every GIs of India, so that the poor people in India can be benefited out of this. So, what I want to say is geographical indication is a community right, a very beautiful intellectual property, which is the only one intellectual property which is allowed community rights and which can get lot of leverage of price premiums and benefit to the poor people, but it will depend upon how you implement it. One of the another highly success story of if you take it from other countries is the Scotch Whisky Association. The Scotch Whisky Association, they go and each and every country and implement, enforce their intellectual property, and everybody to give royalties if you use their name. So, the world famous product whisky, Scotch whisky, vodka and tequila, California apples, many hundred and thousands of products, world famous products, you can sell it in anywhere in the world markets. So, we will move on to the trade secrets, the another category, or I would say that the seventh category of intellectual property law which is mentioned under the TRIPS agreement. So, what is a trade secret? The name itself says, if it keeping something secret, the question is whether it can become a trade secret. The answer is no, it must be related to trade. So, the basic protection of trade secret is provided under the trade secret provisions of the TRIPS agreement. So, you can see very recently or from time to time there are lot of allegations against the employees by the companies, theft of trade secrets. Theft of trade secrets is an offense in many of the countries. In the US, there are special legislations which prohibits, and also there are civil and criminal punishments. So, you can see it is espionage of industrial secrets, trade secrets, data secrets, and taken away by different employees. You can find number of cases, and yes, you can see the Indians are also involved in some of the cases in the US. So, all these news items shows that yes, 20 years in jail term and deportations, punishments, millions of rupees is damages. So, in certain cases it's you can see very interestingly 20 years jail term. In India, so the life imprisonment is up to calculated up to 14 years, and that also again recalculated to some more years less. So, what I want me to say is that the trade secret theft is considered by some of the countries very strictly, and trade secret protection is one of the agenda of the TRIPS agreement. So, what constitutes secret? What secret become trade secret? So, it can be any information with a business person want to keep it as secret, because keeping secret is very important with regard to trade secret. Once it become public, it is no more a trade secret. If the competitors can steal it any point of time, so once it become public, it is no more a trade secret. So, most of the countries have trade secret law, but India does not have a trade secret law. So, and but some of the provisions, common law provisions and other provisions of contract law and other laws are applicable in India as well. So, the definition which gives that, so trade secret is some information, it is not generally known or readily accessible by people who normally deal with such type of information, and that particular information have a commercial value when keeping it as a secret, and also that particular secret was kept as a secret by lawful owner through reasonable means. He have taken all precautions to keep it as a trade secret. So, informations not readily accessible to the ordinary people, a commercial value, and the owner must have taken reasonable means to keep it as a secret. This includes all forms of financial data, business data, scientific data, technical data, economic data, engineering information on patents, plan, analysis, programs, formulas, designs, prototype methods, techniques. You can see that anything which can be kept it as a trade secret. So, you can keep it as a tangible product, you can keep it as an intangible product as well, because now electronically every information can be keep it physically or electronically, graphically. So, any means, and also they must have taken, they have kept this particular information device, and it is very secretly, as well as they have taken reasonable means to keep it as a secret, and accessibility, no accessibility to the outside world, that is also very important. So, India come out with a national innovation bill in 2008 in order to comply with the TRIPS agreement, which says that what do you mean by confidential information. Confidential information, according to that particular bill, confidential information means information including a formula, pattern, compilation, program device, method, technique or process that is secret. So, precise configuration, assembly of its components generally known among other people, has commercial value as a secret. Reasonable steps has been taken by the owner to lawfully keep it, that particular information, as a secret. So, we have taken the TRIPS provisions as such into the 2008 bill. The bill was never passed, and now the government again want to come out with a, so the data protection bill is passed, but still the government want to come out with a trade secret law. So, every company knows that they have trade secret laws, trade secret assets. So, and some of them apply for patents, and some of them apply for other means of intellectual property, but most of the companies want to keep their top secrets as trade secrets. So, for example, why they want to keep it as a trade secret? It is very simple. The patent have only 20 years of protection, and after 20 years it will be in the domain, in the public domain, and trade secret is evergreening until it is leaked, until it is in the public domain. So, one of the most kept trade secret is Coca-Cola mix. For the last 130 years, the Coca-Cola ingredient is kept it as a trade secret. Invented in 1886, and still it is keeping it as a trade secret, no patents. And the trademark value of Coca-Cola only the trademark value of Coca-Cola is 60 billion, calculated to be 60 billion, and this is only for the trademark of Coca-Cola, not the assets. This 60 billion value is only for the trade secret. Once the trade secret is in the public domain, then the entire asset of Coca-Cola is going to be eroded. So, their trademark value is 60 billion, because they kept it as a trade secret for last 130 years. So, this is the geographical indications from Kerala, India, metal mirrors of Aranmula. So, these are completely metal mirrors. So, the India trade secret is known to be by one family. So, it is a mirrors, world famous mirrors used from metals, and the mix of this metal is considered as trade secret. So, from age old times, so everybody knows that traditional style of making the mirrors, but this is specifically made of metal in furnaces and with a the mixing, and it is always kept it as a trade secrets. So, this is only so far now presently there is only 5 artisan families are left for making these world famous mirrors. It is a trade secret. So, once the trade secret is in the public domain, so they no more be able to keep it as a trade secret. So, there can be multiple protections. So, basically the courts in India have consolidated what are the prerequisites of a trade secret. So, this business, this particular information is how much is related to your business, and extent of information known by its employees. So, you have to keep it away from your employees, and the extent of the measures undertaken by the employer to protect the secrecy of the information, the value of the information to the employer, and the amount of effort and money spent to keep it as a secret information, and how easily it can be duplicated by others. So, whether you have access, whether they have access or not. So, access to that such kind of informations, these are the criteria, some of them very important. So, the technical and scientific information, definitely the technical composition of a particular product, for example, a paint, a medicine is very important. Manufacturing methods and know-how, design, drawings and motifs, all these can be very important for a particular product. Technical and scientific information, commercial information, list of clients, so customer buying preferences, supplier arrangements, business plan, marketing strategy, all this can be trade secrets. Financial information, and also some cases industrial informations, industrial intelligence gathering. You collect the intelligence of working of your competitor, and then the products, the negative effects of the products. So, negative information is also can be considered as trade secret. So, the main legal requirement, which includes the information must be secret, it must have a commercial value, and 3, reasonable steps must have been taken to keep it secret. So, if the no reasonable measures have been taken by the owner, readily accessible to his employees or the person who is dealing with it, then it cannot be considered as a trade secret. It won't qualify to become a trade secret. So, these 3 essential legal requirements are very important to keep it as a trade secret. And also we can see that. So, the protection is against improperly acquiring or disclosing or using. So, only theft is prohibited. Independently you can come out with the mix of Coca-Cola. Independently you can do the research and come out the mix of Coca-Cola, that is not the violation of any trade secret law. So, people those who are bound by the duty, they cannot disclose, for example, employees, and most of the time the trade secrets are leaked through employees. So, people those who sign non-disclosure agreements, NDAs, and people who have acquired a trade secret through improper means. So, all these are protected actually, and legal acquisition is not prohibited. And then, so trade secret law, people who discover the trade secret independently, you cannot punish them. So, using legal means they acquired it. And then also you can see that people who discover that particular formula through reverse engineering, a product through reverse engineering, then it is not a violation. So, if somebody makes the Coca-Cola formula through reverse engineering, it is not the violation of trade secret law. And trade secret, as I told you, that trade secret law protects no exclusivity. That means trade secret law is protects from these kind of activities. And at the same time, what are the measures to be taken by the owners in order to avoid the trade secret leakage or protection? So, first of all, you have to do an audit. So, what is the trade secret in your company? Whether it is known to others outside your company or enterprise, whether it is known to your employees involved, and what are the measures you have taken to protect it as a secret? How much effort, how much money you spent, how much effort, how much measures, what are the measures to be taken for keeping it as a secret? Then what is the value of that information? And what is the potential value for your competitors? The same information, if it go to the competitors, what is the value? And how much money you spend for developing it? How difficult it is to acquire or how difficult it is to duplicate? Second, every company must develop a trade secret policy. So, that means every company must have a trade secret policy. First, you identify the products, identify the documents, and then you restrict the access. So, that means every company, every establishment must have a trade secret policy and for protection. Then you educate the employees. So, you educate the employees and you tell them that how you are going to be liable for disclosing such trade secrets, and enter into non-disclosure agreements, non-competing agreements with employees. And also you have to tell that what are the your obligation towards the former employer and the present employer, and there must be exit interviews. There must be exit interviews of employees, those who are working in very critical fields, those who have access to data, and you have to make it sure that they do not have access to that data at the last moment. You restrict access. How you restrict access? Then every employee must know what he is supposed to know, not more than that. So, the information he must know only to the extent of his knowing that particular employee. Restrict access. Then mark the documents with different colors, important, confidential, and this documentation, keeping it now in the digital era, it is very difficult to keep as this information confidential. So, you have to take additional efforts, cyber security schemes, cyber security to be increased to keep these informations confidential. Emails, what email you can send from your company and what email you can receive from your company, whether these employees are using it for personal purposes, every company to take into account. And physically isolate and protect this information, whether it is in computer format or in the hard format. Access control, login controls, surveillance. Now, surveillance also most effective is electronic surveillance, and certain documents is to be destroyed, shredding. This also you have to do it. Then the most important thing now every company to take care of is maintain the computer secrecy. Now, everything is online transactions. So, it is through websites, it is through intranets, it is through internets, it is through emails. So, access control system must be established and confidential information to be separated. There can be a digital separation as well as physical separation of and put it in lock and key, or this information to be shifted to some other the locations, safe locations, even in computer the facilities, safe servers, and then remote access. You have to monitor the remote access. So, all the you can see that the cyber or the digital the complete digital security is to be implemented at every establishment for so in order to keep maintaining these particular secrets. So, today we talked about geographic indication, today we talked about trade secrets. So, we talked elaborately on the geographic indications. So, the geographic indications always a particular product related to a particular geographical origin, where it is Odisha Rasgulla or it is Bengal Rasgulla. So, it is all related to that particular region. It is famous because of that particular region and of the reputation or the product, and this is the only one community right which is available within the entire 7 category of intellectual property law. It cannot be owned by an individual, even though all intellectual properties are private rights. When it comes to the trade secret law, and in some of the countries like the US, there are special legislations like the Industrial Espionage Act, the trade secret law. Every state have a trade secret law, but India we have still not developed a trade secret law. The TRIPS agreement obligations are very simple with regard to trade secrets as well. So, the TRIPS defines what constitutes a secret, trade secret. The basic minimum criteria is provided by the TRIPS agreement. So, I have explained to you some of the measures every establishment to adopt keeping this information secret. So, India we do not have a special law, and but we uses the common law and common law principles as well as other legislations. So, but the breach of confidence and breach of agreement, breach of other contractual obligations are dealt under the civil law. So, there is very little scope for punishment. So, what I want to say is that India should develop a full fledged trade secret law, because it is a high time after 26-27 years more and more companies, foreign companies are coming to India for doing business. So, they have to keep their trade secrets intact. So, if there is no legislation and the protection is under the common law, it will be very difficult for enforcement. So, at the same time the geographic indications, there must be provisions for the price premiums to be distributed to the at the lowest level of producers. So, these two categories of intellectual property law, especially GI law, is very important for India in the future, and the number of registrations to be increased, because the whole world is registering all their assets, intellectual assets. India also should register more and more number of assets, maybe 5,000 to 10,000 products which you can identify from India. So, the present pace, if they going, they may take next 50 years to register 10,000, because so far they have hardly registered 450 to 500 geographical indications from India. So, this as an the TRIPS obligation, India has to implement the trade secret law as well, and the Indian category of 7 category of intellectual property law is very important for the present traders, because everybody must know the present TRIPS agreement, because 164 countries dealing with the TRIPS agreement, and they have to implement at the domestic level uniformly. The minimum standards to be implemented uniformly, including India. So, this is all about the TRIPS agreement and the intellectual property protection. Thank you.